Under the Federal Fair Labor Standards Act, employment is broadly defined as to suffer or to permit work. While the Act only defines volunteers with respect to state and local agencies, the Department of Labor considers the Act's definition when making its own determination of whether a worker is a volunteer at a church, ministry, or nonprofit organization. According to the Department of Labor, a volunteer is an individual who performs hours of service for civic, charitable, or humanitarian reasons without promise, expectation, or receipt of compensation for services rendered. Basically, an individual is a volunteer so long as, 1, he or she receives no compensation apart from reasonable reimbursement or allowance for expenses actually incurred, and 2, such services are not the same type of services for which the individual is employed. Now, issues may arise where an nonprofit employee decides to volunteer for the same employer. Under the Fair Labor Standards Act, an individual may not be treated as a volunteer if the employee is otherwise employed by the same entity to perform the same type of services as those for which the individual proposes to volunteer.